సార్ కంప్లీట్ ఇంగ్లీష్ కదా, చెప్పండి దాన్ని బట్టి. బైలింగ్వల్ ట్రై చేయాలి, ఇంగ్లీష్ ఓకే 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 స్టార్ట్. Yeah. Good evening, students. Welcome to our dominant prelims program. As part of our dominant prelims program, today we are starting with polity, and we have named this series as polity hit series, which means highly important topics series. In this we have divided the topics into three different categories. See, we have divided the topics into 5-star, 3-star and 1-star categories. In these dominant prelims series, we will be discussing the 5-star topics, and the 3-star and 1-star and the 3-star and 1-star topics we will be giving about the topics and relative and the content regarding those topics. Okay. And here these 5-star topics are those which are most important for the exam and which are having chance of reflecting in the exam. So these are the topics when there is 1 day or 2 days before the exam, these are the topics which you need to revise more. Okay. Next. Now starting with the topics, is it okay? Shall we start, students? Yeah. First of all, we will be starting with the most important articles in news. Okay, most important articles in news. And regarding the articles in news, first of all, if you go through the last 10 years question papers of polity, the major articles which have been from either from the chapter of judiciary or from the chapter of fundamental rights. Okay, so considering this, we will be first discussing the articles which are in news related to judiciary. These are the most important articles which are expected in the exam. Okay, and coming to the first article, Article 131 of the Constitution. Okay, Article 131 of the Constitution. To what does this Article 131 is related? Tell. Article 131 of the Constitution is related to original jurisdiction of the Supreme Court. Right? Original jurisdiction of the Supreme Court. What does this original jurisdiction mean? Original jurisdiction means one in a specified case, the aggrieved person or the party can go directly to the Supreme Court, not by way of appeal. Okay, means for example, take a civil case or criminal case. We can't go directly to the Supreme Court. At the first we need to go to the lower courts, then to High Court, and finally to the Supreme Court. But under this Article 131, this original jurisdiction, we can directly go to Supreme Court. This is called as original jurisdiction. And in this also there is original jurisdiction and exclusive original jurisdiction. There is original jurisdiction and exclusive original jurisdiction. Okay, what is the difference? In original jurisdiction, it means one can go directly to the Supreme Court, but it doesn't mean that one cannot go to High Court. But exclusive original jurisdiction, one must go directly only to the Supreme Court and they cannot go to the High Court. And in this Article 131 is exclusive original jurisdiction of the Supreme Court. Take for example, if there is any problem with regard to fundamental rights, it is an original jurisdiction of Supreme Court, but there is concurrent jurisdiction for High Courts also. Okay, so at that point of time we cannot say that it is exclusive original jurisdiction of Supreme Court. Okay, for example, Article 32. Now in this situation, so finally this Article 131 deals with original jurisdiction of the Supreme Court, and also there are specific cases which are mentioned directly in the Constitution of India. On what cases we can go to Supreme Court under Article 131. What are those instances? When there is some sort of issue or problem with respect to between Government of India and one or more states, or there is problem with respect to between two different states, or there is a problem when two or three states on one side and central government and other states on the one side. So the major thing which Article 131 deals is federal disputes. Okay, all the federal disputes will be dealt under this Article 131. But there are some specific issues even in the federal cases. There are some specific issues which cannot be taken to the Supreme Court under Article 131. What are those cases? What are those cases? Answer please. No, not like that. Even this is directly mentioned in the Constitution itself. Those are, first, what we are telling here, if there is dispute between central government and state government, we can go to Supreme Court under Article 131. But if there is a dispute regarding an issue which is pre-constitutional, means before the enactment of Constitution, if there is any issue, pre-constitutional agreement, pre-constitutional treaty, so to those cases, these states cannot go under Article 131. Okay. Next, if there might be some laws which itself directly mentions that there is no original jurisdiction of Supreme Court in these laws. Even in those cases also, they cannot go to Supreme Court under Article 131. Next, as per interstate water disputes, in Article 262, it was clearly mentioned that Supreme Court doesn't have original jurisdiction in solving these water disputes. Okay, so it is also not allowed. Next, with respect to the decisions of Finance Commission, at that point of time also Article 131 does not apply. Next, if between central and state governments, if there are disputes which are of commercial nature, those also not allowed. Okay, and there might be issues with respect to the expenditures, pensions between central and state governments. Yes, so these 6 issues cannot be taken to the Supreme Court under Article 131. Okay, so this is the main crux of this Article 131. Okay, next. Now, why this Article 131 is in news? Because what happened that Kerala government had went to Supreme Court challenging, they want to take some extra borrowing, but central government is not allowing them. So as to counter this, they had went to Supreme Court, but central government had filed a petition with the Supreme Court that please don't allow that petition. Then Supreme Court told the central government that we cannot say that, because Article 131 it says that federal disputes is the original jurisdiction of Supreme Court and central government cannot tell us not to take it. Okay, that's why it is in news. Yes. Next. Next, Article 136. What is this Article 136? What is this Article 136? This is special leave jurisdiction. Article 136 deals with special leave jurisdiction. What does this mean? See, for example, in the earlier case, we had seen that Interstate Water Disputes Act clearly mentions that states cannot go to Supreme Court to solve these water disputes. But even in those cases also, Supreme Court can entertain a dispute. They can take a case under this Article 136. That's why it is called as special leave jurisdiction. Be it any case, any dispute, it is be it already given judgment has already been given, or it is in the middle stage, or it is in the stage of appeal, but Supreme Court can take it leave. They can take, if someone is filing for special leave petition, it can accept. But the thing here is that all of you might be knowing this Article 32. What is this Article 32? Sorry? Constitutional remedies. Okay, so right to constitutional remedies. Under this article, if a person is going to the Supreme Court cannot deny, accept, it must surely accept the petition. But in this Article 136, it is not mandatory for the Supreme Court to accept any petition. If it feels that it is needed, then only it is its own discretion to take the case or not. Okay, that's why it is called a special leave petition. Next, this special leave petition is available only with the Supreme Court. Okay, under Article 136. Next, also this we had taken this special leave petition from Government of India Act 1935. Okay, we had taken this special leave petition format from Government of India Act 1935. And the most important thing here is that we can against any judgment from be it lower court, high court, or any court from in India, we can go and file a special leave petition with the Supreme Court, but except military courts and tribunals, this court martials. So we cannot go against the judgment of military courts and court martials to Supreme Court under Article 136. Okay. And also there is a rule that a special leave petition must be filed within 90 days from the date of judgment, or must be filed within 60 days against the order of the High Court refusing to grant the certificate of fitness. Okay. So if High Court had given a judgment today, if we want to file a special leave petition from the with the Supreme Court, it must be only up to 90 days. Before the completion of 90 days, we must, if we want, we have to file the case with Supreme Court. Okay. Next. Sorry? Yeah, so 60 days is that. See, generally there is a article in the Constitution that if against a judgment of High Court, if we want to go to Supreme Court, High Court must give a certificate of fitness for appeal. Okay, but if High Court is not giving, or if High Court is refusing, you can go within 60 days for appeal with the Supreme Court under this article. Okay. Now, why this is in news? Because Supreme Court in this state of Punjab versus Gurpreet Singh and others held that Article 136 of the Constitution, under this, it can also cancel the acquittal of the convicts. Means, for example, High Court had freed the persons who had made one crime due to some issues. But if Supreme Court says that it is not correct, it can take back that acquittal. Okay. Sorry? Yes, it is also related to the same thing. Next, Article 142. Now, first of all, why we are discussing these articles with respect to Supreme Court or judiciary? Because these are the things which are being asked by the UPSC. Say, for example, in 2019, they had asked about this. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as a prohibitions or limitations on the constitutional powers under Article 142. If we know the original context of these articles, we can easily answer those questions. Okay. Not only this, many questions which are related to the judiciary of the same background have been asked. That's why we are discussing this first. Now, what is this Article 142 is related to? What is this Article 142 related? There is a keyword. Doing complete justice. Okay. Doing complete justice means under Article 142, Supreme Court can give its judgment or pass an order if it considers that by doing that it can do complete justice to the people, because as a guarantor of the protector of the Constitution or also guarantor of the fundamental rights, it is the duty of the Supreme Court to protect do complete justice to the people. So under this Article 142, Supreme Court is having a lot of amount of powers. By this it can pass any orders, and these orders are enactable by all the parties. Okay. And recently, where does Supreme Court had used in landmark incident? Supreme Court recently nullified the outcome of the Chandigarh mayor election, exercising its power under Article 142 of the Constitution to ensure complete justice. Okay. What is this Chandigarh mayor issue? You might have seen in the YouTube reels or somewhere that one civil servant, one IAS officer is changing in Chandigarh mayor election, he is changing the voting process by sitting. In the CC camera it had been captured. Seeing this, Supreme Court had taken this, and it had using its powers under Article 142, it had nullified that election. Okay. That's why it is important now. Next. Yes, Malika, it is complete justice, Article 142. You have seen this? Next. These are the important articles in use with respect to judiciary. Now, coming to schedules. Time and again, since in the last 10 years papers also, there is mandatory, there is a question with respect to schedules in the prelims paper. Okay. So, we will be discussing the schedule which is in use. And here, 6th schedule is highly in use. Why? Because, sorry? Not only that thing, the reason why 6th schedule is in use because there is a high demand for sanctioning 6th schedule status to Ladakh. Sonam Wangchuk and their public representatives are asking to give 6th schedule status to Ladakh. Okay. So in this context, 6th schedule becomes important for our exam, and we will be looking into this provisions under 6th schedule. Okay. This 6th schedule of the Constitution is under Article 244 of the 2 and Article 275 of 1. Remember these two articles, Article 244 and Article 275. And to which 4 states this 6th schedule belongs to? Remember this. AMTM. Okay? AMTM. AMTM. AMTM means Assam, Meghalaya, Tripura and Mizoram. Assam, Meghalaya, Tripura and Mizoram. And it also empowers the governor to create autonomous district councils and autonomous regional councils in these 4 states. Autonomous, where we will be creating autonomous regional councils? If, for example, in a district there are more number of tribes and there is no proper representation to them. In those situations, governor can go with creating autonomous regional councils also. Okay? And coming to the representation in this autonomous district councils, there will be 30 members, not more than 30 members, and in these 30 members, 4 members will be nominated by the governor. Remaining 26 members will be elected. But there is exception here, Bodoland Territorial Council. Bodoland Territorial Council can have up to 46 members. Okay, this is exception here. Also, as I told you earlier, autonomous regional councils, when there are more number of tribes in a district, governor can go with creating autonomous regional councils also. Next, these 6 schedules, what is the main premise of the 6th schedule? Because there are some tribal areas which are relatively less developed. So in those situations, to go for their upbringing, we are giving some extra powers to those people in the way that there will be more democratic decentralization. How? Because many powers will be given directly to the people. For example, executive, legislature and judicial powers will be given to the 6th schedule to ADCs and ARCs. How? See, for example, if the governor finalizes some sort of jurisdiction, those cases can be solved by ADCs only. Similarly, there are some legislative and executive powers with respect to this 6th schedule. All the laws of the state government and parliament do not apply to this. they will be applying with some modifications. Okay. Now, why this is in news? Because a high powered committee has been established to examine whether to give 6th schedule status to Ladakh or not. Okay. And these are being demanded by Sonam Wangchuk and their MP Jamyang Shering Namgyal. Okay. Next. Yeah, why I am telling that this is important? Because see, 2015, 18, 19, 2020, 2022, 2023, in all these years there is a question related to schedules. How many schedules are there? How many schedules are there? 12 schedules are there, okay? 12 schedules are there. In this 12 schedules, you need to know each and every clause of this, all these 12 schedules, because if at all a question comes in the schedule, it will be a low hanging fruit for you, because you may not, because you can surely get it correct. Okay. See, earlier question regarding 5th schedule has been asked, 9th schedule has been asked, 10th schedule asked it twice, 5th schedule asked it number of times. Next. This all the 12 schedules. And mnemonic for this is, all of you might be knowing this also, tiers of old PM. Okay? Tiers of old PM, 12 schedules. So tell me those 12 schedules. First thing, T means here name and extent of states and UTs. Territories of states and UTs. Okay. Next, E, emoluments. Emoluments. A, affirmations and oaths. Listen this clearly, very important. Are Rajya Sabha seats. Yes, scheduled areas, 5th schedule areas. Sixth schedule is other tribal areas. We had seen, what are those 4 states? AM, TM. F, 7th schedule is federalism. Union list, state list, concurrent list. So related to federal provisions. Official languages. How many official languages are there in 8th schedule? 22. Is English part of this official language? English is not part. English is not part of this 22 languages. Okay. Next, 9th schedule. Legislations. Legislations which are to be kept out of judicial review. Is this 9th schedule only for the central government acts? Okay. So both state and central government acts which they want to keep them out of judicial review can be kept in this 9th schedule. But after the case of IR Kohelco, there is no blanket immunity. They are subjected to judicial review now. Next, 10th schedule is anti-defection. Eleventh schedule is twelfth schedule municipalities. Okay. So sure shot one question is guaranteed from the schedules. So don't make mistakes in these sort of easy questions. These are low hanging fruits for us. Next, these 12 schedules, what is the mnemonic? Tiers of old PM. Okay. And in this, territories, emoluments. Who all will be there here?
President, Prime Minister, Speaker, Deputy
See, in both second schedule and third schedule, judges and CAG are common. Okay? Judges and CAG are common in both second schedule and third schedule. But other than that, in second schedule and third schedule, here constitutional offices are also present. Constitutional offices. Who are those? President, Governor, speakers, presiding officers. Be it speaker, deputy speaker of central government, state government and all. Similarly here, in third schedule, judges and CAG, along with them, all those who will be participating in the elections, all those who are got elected as public representatives, means MPs, MLAs, MLCs and all. MPs, MLAs, MLCs, and here who are participating in the elections, they have to take the oath, no? Their oath is also, their affirmation is also part of third schedule. Okay? Fourth schedule, Rajya Sabha seats and all, remaining is same. Okay? Next. Okay with the schedules, right? Next. Citizenship Amendment Act. You might be knowing this all. It is highly in news. But why we are discussing? Because earlier there used to be no questions from citizenship chapter. But from the last two prelims, they are giving questions from citizenship also. Okay? Citizenship Amendment Act. And why it is most important now? Because recently the procedure for Citizenship Amendment Act started now. Officially it got enacted now. Recently, around 1 month back, people who got citizenship under this CA 2019, their certificates are also given to them. Now, implementation of Citizenship Amendment Act started from March 11th. Okay? Started from March 11th. Now, under this, what happens under the Citizenship Amendment Act? People belonging to 6 religions leave Muslims. What are those 6 religions? Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. People from these 6 religions who had come to India as illegal migrants from 3 different borders, Pakistan, Bangladesh and Afghanistan, before cut-off date of December 31st, 2014. December 31st, 2014, they will be given citizenship of India. Okay? They will be given citizenship of India. Okay? Here the cut-off date is December 31, 2014. Now, March 11, 2024, the rules have been started implementation. And why these? Why there is need of this Citizenship Amendment Act? Basically, because there is an issue of persecution of these 6 minorities in other countries, which you had seen now. All those 3 countries. So, to protect their interests, we had given citizenship rights to them. And also, this law exempts tribal areas of 6 schedule states as AMTM states, and also tribal areas of Karbi Anglong in Assam, Garo Hills in Meghalaya and Chakma district in Mizoram, and tribal districts in Tripura. These areas are excluded from this CA Act. Okay? And one more thing, in this Citizenship Amendment Act, there is a provision for the cancellation of OCI registration. Okay? Who is OCI? Overseas citizen of India. Does OCI people have voting rights in India?
No, sir.
See, OCI is different, NRIs are different. NRIs are Indians only. But OCI do not have citizenship of India. Okay? They are citizens of other countries. Due to some reasons, they might be given OCI membership. Okay? And there will be some benefits if one gets OCI membership. And in this scenario, if in this CA 2019 they had mentioned that OCI registration can be cancelled if those OCI card holders violated any of the provisions of the Citizenship Act. Okay. Next, in the citizenship chapter, in the static part, you need to study how to gain citizenship, what are the ways to gain citizenship, and what are the ways to lose it. Right? What are those ways?
By birth, by naturalization, by registration.
Yeah, by birth, by naturalization, by registration, and by ways to lose it?
Renunciation, termination.
Renunciation, termination. Yes. Check this tomorrow, tell me in the class. Okay, this is important.
And other provisions.
Yes. Now this is the PYQ in 2021 regarding citizenship, because earlier before 2020 there is very less focus on this chapter, but now citizenship chapter is also gaining importance because there is high level of news with regard to the topic also, no? That's why. And also many topics of polity have been covered in the last 10 years. So if they have to go to some new areas, citizenship chapter would be a one. Okay. Next, food safety regulations in India. Food safety regulations in India, they are in news, highly in news. Why? Because firstly there are some amendments in the food safety regulations, and one more thing, because recently you might have seen in Nestle's Cerelac, there is a report told that in Nestle's Cerelac there is high level of sugar. More than sanctioned amount, there is high level of sugar in this child. Small children will be taking this Cerelac, no? Yes. So it is against the law. One report had shown this. A report from a study by International Baby Food Action Network and Switzerland-based investigation agency had found this. So in this scenario, there is doubtfulness and also apprehensions with regard to food safety in India. So in this context, we need to know about the food safety regulations and food safety rules in India. Okay, that's why we are discussing this. And what are the main two things which will be governing food safety standards in India are Food Safety and Standards Act 2006. This is the main legislation, and Food Safety and Standards Regulations 2011. These are the concerning regulations with respect to that act. Okay, what is the act? Food Safety and Standards Act 2006. This created the statutory body called FSSAI. Okay, and in this Food Safety and Standards Regulation 2011, it contains about labeling requirements, standards for packaging food, and also permitted food additives, microbiological requirements and all. Okay, all those things will be mentioned in these rules. Next, Food Safety and Standards Authority of India. This statutory body has been created under which act?
Food Safety and Standards Act 2006.
Food Safety and Standards Act 2006. It is an autonomous statutory body. Okay. By creation of this body, earlier there used to be multiplicity of laws and also bodies overarching framework. With this enactment of this act and the creation of this body, the process got simplified. This act aims to establish a single reference point. Okay, and the FSSAI headquarters is in New Delhi. The chairperson of this FSSAI is appointed by central government, and the chairperson is the rank of secretary to the government of India. Okay, and this will be operating under the Ministry of Health and Family Welfare. It will be operating under the Ministry of Health and Family Welfare. Next, Quality Council of India. Quality Council of India. Earlier there is a question on this food safety standards and also this Quality Council. That's why, because in the last 3 to 4 months they were highly in use. Not only regarding this, see for example, there is a component called rhodamine in Manchuria or some sort of these coloring agents. It was banned. So in all these contexts, this gets important. Here this Quality Council of India has been established in 1997 under the Ministry of Commerce and Industry. Okay. Now it is registered as a non-profit organization under the Societies Registration Act. Okay. This Quality Council of India operates through two main bodies under it. One is National Accreditation Board for Certification Body, and National Accreditation Board for Testing and Calibration. What does this main duty of Quality Council of India? To checking the quality, right? So the bodies under this Quality Council of India will be doing this. And the main thing here is that the chairman of Quality Council of India is appointed by the Prime Minister based on the recommendations of the industry. Okay? The chairman is appointed by Prime Minister. There are very less instances where Prime Minister will be appointing. This Quality Council of India chairman will be appointed by Prime Minister based on the recommendations of industry. This is a previous year question also. Next, regarding this food safety thing, another main things are BIS and AGMARK. You need to learn those also. As I told earlier, no, there are 5-star topics, 3-star topics and 1-star topics. These BIS and AGMARK will be coming under those 3-star topics. Okay. Next, UAPA Act of 1967. One second. UAPA Act of 1967. What does this mean? Unlawful Activities Prevention Act of 1967. The major reason for enacting this is controlling terrorism, anti-national activities to safeguard the security of India, right? And the major thing you need to know about this is that under this, we based on the 2004 amendment, terrorism is also added under these provisions, UAPA. Okay? And who will be taking care of this? It empowers the National Investigation Agency, NIA, to investigate and prosecute cases under UAPA. So, who is having the jurisdiction of this UAPA? NIA, National Investigation Agency. Now, and one more thing, our individuals can be marked as terrorists?
Yes.
Earlier, before the amendment of 2019, only terrorist organizations can be banned under this UAPA. But after the 2019 amendment, even individual terrorists can also be banned under UAPA. Okay? And this act extends to the whole of India. The 2019 amendment gave the Home Ministry the power to designate individuals as terrorists. Okay? 2019 Act amended earlier, before 2019, there is no power for Home Ministry to ban individuals. Okay? Now, why this is in news? Because recently some groups have been banned under this UAPA Act. Muslim Conference, Jammu and Kashmir, Sumji faction, Muslim Conference, Jammu and Kashmir, Butt faction. They have been banned for a period of 5 years. And also individuals like Harvinder Singh Sandhu, these also have been banned. Okay? Jamaat-e-Islami of Jammu and Kashmir has also banned for a period of 5 years. Okay? Next, PMLA. It is highly in use because there is apprehension from the opposition parties that ruling party, this is just an apprehension from the opposition parties that they are alleging that ruling government is using enforcement directorate against them, right? Ruling government is using enforcement directorate against them. That is the allegation. These are the allegations of opposition parties. In this context, and also there is high level actions with respect to ED also. So in this scenario, PMLA Act becomes important. Now, the major reason for this PMLA Act is to combat money laundering. Okay? combat money laundering. Prevention of Money Laundering Act, right? So the act had been enacted to combat money laundering. And in this scenario, why we had to enact this law? There is an Article 253. Article 253 in our constitution. It says that to give sanction to international agreements, Parliament of India can make some acts. In this scenario, we had agreed in UN General Assembly and also FATF. What is FATF?
Financial Action Task Force.
Financial Action Task Force. It is related to money laundering, this
State-sponsored terrorism.
weapons of mass destruction. To control all these activities, Financial Action Task Force have been created. So India had accepted in this UN General Assembly and Financial Action Task Force that we will be creating one legislation to control this money laundering. In this context, we had created PML Act in 2002. Okay. And under this, the three main objectives are to prevent and control the money laundering, to confiscate and seize the property obtained, and to deal with any other issue connected therein. Okay. They had the powers to confiscate also. Confiscate and seize. You might be seeing no, in ED rights and all, they will be confiscating the property. Once those accounts are freezed, until they are at the in the final spot, they will be giving that no clearance certificate. Until then, they will be giving those clearance certificate only if there is no mistake found from those people. Okay? Until then, those accounts will be freezed. And here, Director Financial Intelligence Unit and Director Enforcement have been conferred with exclusive and concurrent powers under relevant sections of this Act. Means who will be implementing this PMLA? Enforcement Directorate, ED, and Financial Intelligence Unit. Okay? These two bodies having exclusive and concurrent powers. Okay? Now, why it is in news? Because mainly Enforcement Directorate had asked the Supreme Court that we will be marking Aam Aadmi Party as a convict or accused in Money Laundering Act. This is the first such instance, because earlier, since independence, many individuals or many companies have been booked under PML Act, but no time a party has been booked. So they had asked the Supreme Court. And ED said that it is planning to invoke Section 70 of the Prevention of the Money Laundering Act. Under Section 70 of the Prevention of Money Laundering Act, it is allowed to take a party's name. Okay? Now, Sita Soren versus Union of India case. In the last 10 years, since 2013 to 2023, although regarding the judgments, there are no direct questions, but the backstory of those judgments are needed to answer some questions. Okay? And seeing the last 2 years papers, it is even more important now. Okay? And this is the landmark judgment which had been given in Sita Soren versus Union of India case in 2024. In this case, Supreme Court's earlier judgment in PV Narasimha Rao case have been overruled. This PV Narasimha Rao case is related to 1998 judgment in the PV Narasimha Rao case is related to parliamentary privileges. Parliamentary privileges means it says that whatever MPs or MLAs are saying in their respective houses cannot be questioned. They are having parliamentary privilege. And this is the final stance of Supreme Court in this PV Narasimha Rao case also. But now what happened? There is a case that in the Sita Soren case, in one Legislative Assembly of India, it is Jharkhand, I guess, one person have been bribed, one MLA have been bribed to speak something in that person's favor, in one person's favor. Yeah, so it is a wrong thing, right? So in this scenario, Supreme Court had overruled its earlier judgment in the Sita Soren versus Union of India case. Okay? The judges asserted that there is a flexibility in the doctrine of stare decisis. What is this doctrine of stare decisis? As per this doctrine of stare decisis, if there is a judgment of Supreme Court, it can be overruled by Supreme Court if there is some larger bench. Okay. See, if for example, earlier this judgment have been given by five judge bench. Now to overrule this judgment, 7 judge bench has been created. They are given the judgment. This is called as doctrine of stare decisis. Okay. What this says, MPs and MLAs accused of taking bribes cannot claim any immunity from prosecution under Article 105 and 194. What are these articles 105 and 194? Come on guys. These are the articles related to parliamentary privileges. Okay. These are the articles related to parliamentary privileges. So earlier as per previous Narasimha judgment, whatever one person is speaking in their respective houses, there is no second question on them. Now in this Sita Soren cases, it says that it is no complete blanket immunity. If they are accused of taking bribes, we cannot accept them. Okay.
Parliamentary emolument salaries and all they come under Article 100.
This parliamentary privileges will be coming under this 105.
Emoluments, salaries, all those will be covered under.
Yes, yes. 105 and 194. Next, and also in the same case, so Supreme Court under head of this bench is Chief Justice of India only, D.Y. Chandrachud. He told that Rajya Sabha is the part of basic structure doctrine. Rajya Sabha is part of basic structure doctrine. Why he told this? Because, see, who will be electing the members of Rajya Sabha?
MPs, Lok Sabha.
MPs. Who will be electing the members of Rajya Sabha? State MLAs will be electing them, right? MLAs from the state assemblies will be electing the members to Rajya Sabha. In this scenario, if the actions or their freedom of speech is being affected by bribery, and then the people who will be going to the Rajya Sabha will also be of some accused, right? So since Rajya Sabha is a part of basic structure of the constitution, we cannot allow this parliamentary privilege completely. These are the statements of Honorable Chief Justice of India. Okay. Next, constitutional morality. What is constitutional morality? First of all, what is morality?
Being accountable, responsible.
Yeah. What is morality?
Responsible.
Yeah, means accepting something or being responsible to some specific thing. Here constitutional morality means we are adhering to the constitutional values enshrined in our constitution. This is constitutional morality. Means we are seeing that as our guidebook. We will be following we will be taking our decisions based on the values enshrined in the constitution. So this is called as constitutional morality. Okay. Now, constitutional morality is a concept that refers to the principles and values underlying the constitution that guide the actions. Our actions, be it of government or the private individuals like us, our actions must be based on the constitutional values. It is called as constitutional morality. Okay. There might be situations that some actions can be against the constitutional morality. Okay. Social morality is there, constitutional morality is there. Okay. In India, the term was first used by B.R. Ambedkar. Okay. And is constitutional morality explicitly mentioned in the constitution?
No, sir.
Yes, it is not mentioned in the constitution. And also remember these things in the next 20 days when you will be revising polity. This advice is specifically for polity. When you will be revising polity, keep an app of Constitution of India app. Just go through the articles, the context, direct the clear context which is mentioned in that constitution article. Okay, it will be very useful. So the term constitutional morality is nowhere explicitly mentioned in the constitution. Is judicial review mentioned?
No, not directly.
Okay, means I am asking explicitly.
It's not mentioned.
Explicitly it is not mentioned. Okay. Next. Now why we have discussed this constitutional morality concept is that because since last 4 to 5 years repeated questions with respect to constitutionalism, constitutional law, constitution, they are being asked. Some sort of philosophical thing. So you need to know the background of these topics. First of all, what is constitution?
It's a law book. It's a guide to the country.
What is the main purpose of creating a constitution?
To limit the government.
The why constitution is created, that major function is it will be differentiating the functions between legislature, executive and judiciary. It is a major function. Okay? Constitution divides the functions between legislature, executive and judiciary. Now, what is constitutionalism?
Ideology of constitution.
Constitutional government. These are previous year questions. Constitutional government means limited government. Why? Because since constitution is there, there are some restrictions on the powers of the government, be it central government or state government. If that book is not there, there might be no restrictions, right? So constitutional government is the one, the powers of the government have been restricted or limited by the use of that constitution. Okay? This is called as constitutional government. Constitutionalism means the functioning of the government is completely based on the ideals of the constitution. It is called like constitutionalism. Okay? And you need to know just these basic things about constitutionalism and constitutional government means limited government. Okay? And many questions in the last 5 to 6 years have been asked that, see, for example, in the context of Indian constitution, from the perspective of Indian constitution, what does liberty mean? What does equality mean? Okay? So you need to have the idea of those words with respect to Indian constitution. See, for example, liberty. There is a different meaning for liberty, but there is positive liberty, negative liberty and all. Liberty means generally absence of restraints, but this is negative liberty concept. Okay? But positive liberty means providing opportunities. Providing opportunities to develop oneself fully. Okay? Providing opportunities to develop oneself fully. This is positive liberty. Our Indian constitution uses this idea of positive liberty. Okay? See, for example, take difference between positive liberty and negative liberty. In negative liberty, if I have to, my home place is Visakhapatnam. I am in Hyderabad. There is no restriction from the government for me to go to Vizag. This is negative liberty. But, okay, means there is no restriction, absence of restraint. I can go to Vizag. But if government of India is providing roads, creating RTC, it is creating an opportunity for me to reach my goal. So this means positive liberty. It is creating certain conditions which will be helping me to achieve my goal. This is called as positive liberty. Okay? This slight difference. Our Indian constitution ideals this positive liberty concept. Okay?
Yes.
Welfare state. Welfare state means?
Providing opportunities for development for poor.
Welfare state is anywhere mentioned in the constitution? Yes, it is mentioned in our directive principles. Okay? Welfare state means state is doing some sort of welfare policies to uplift the livelihood of the people. Okay? Here state is considered as a fatherly figure. How our parents will be taking care of us, similarly state will be taking care of the people. Okay? State will be taking care of the people. Similarly, you need to study about the concept of equality, socialism. In socialism also there is Indian socialism, Western socialism, secularism, rights, fraternity and all. You need to just maintain one pager for these topics. Okay? Rights, equality, privileges, fraternity, constitutionalism and all. Okay, welfare state. Next. Now since elections are in place and all the news regarding the last, why I am covering these topics, because you might have left the current affairs or newspapers in the last 3 to 4 months when you will be going into peak preparation stage. That's why in this class I am covering the topics which are in news in the last 3 to 4 months. In tomorrow class you will be seeing the brief about the topics in the before 6 months from May. Okay. EVMs. Most of you might be have already voted. So EVMs are some sort of device to record votes electronically. Okay. Now a EVM can maximum capture 2000 votes. Regarding EVM, there won't be any concept, but you need to know about some facts regarding this. If at all a question or a single statement in a larger question is possible this year, since this is a general election year. Okay. First time it was conceived by Election Commission in 1977, but it was first used in Paravur Assembly constituency of Kerala in 1982. But in general elections, first time it was used in Goa Assembly in 1999, and for complete India, it was first time used in 2004 Lok Sabha elections. Okay, first time completely over India, it was utilized in 2004. Okay, and now who will be manufacturing these EVMs? Not BHEL, it is BEL, Bharath Electronics Limited. BHEL is Bharath Heavy Electricals Limited. Okay, BEL and ECIL. Combinedly, these two public sector units will be making this, manufacturing these EVMs. And in these EVMs, there will be two parts, control unit and balloting unit. Balloting unit is the wing where we will be voting. Control unit will be with the polling officer. Okay. And there is no requirement of any electricity, and chip is also not modifiable and all. Okay. It is based on ordinary battery, and there is no operating system in this to get hacked.
Yes. Just like a calculator.
Yes. Next, voter verifiable paper audit trail, VVPAT. This EVM machine, since you had already voted, EVM machines and VVPAT machines will be used in our election. What happens in this VVPAT? Yes, in this VVPAT there will be again two units, two parts. One is VVPAT printer and VVPAT status display unit. The printer will be printing in this status display unit to which person we had voted, the symbol and the name and number will be displaying in this. Okay, and there it will be seen for 7 seconds, right? First time in India it was introduced in 2014 Lok Sabha elections. 2014 Lok Sabha elections. And again VVPAT is also developed by ECIL and BEL. Okay, and this VVPAT has been sanctioned by Supreme Court under Subramanya Swamy case. Okay, in Subramanya Swamy case, Supreme Court told to ECI that VVPAT is mandatory. Okay. Next, star campaigners. Who are star campaigners?
Popular citizens of India.
Not like that. There is no rule or restriction to keep someone as star campaigner. It is a discretion of the political party to have star campaigners. But how many star campaigners are there? It will be decided by the election laws. And presently, recognized political party. What is this recognized and unrecognized? There is national party, state party, national party, state party, and unrecognized parties. Unrecognized parties. What is the difference here? All these parties are registered. First of all, to contest in election, one specific party must register. But based on the votes and the number of seats, they will be giving recognition. It is called as national party recognition or state party recognition. There are different criteria for this, and it is very important for this exam also this year. Okay. Tomorrow tell me about criteria for national party recognition and state party recognition. Okay. Is AAP a national party now? Aam Aadmi Party a national party now?
It's a national.
Yes. Recently it got recognized as national party. Okay. And as per this election laws, there is 40 star campaigners for recognized political parties and 20 star campaigners for unrecognized political parties. And for the star campaigners, their expenditure is not counted in the election expenditure of individual candidate. Okay. Their expenditure will be counted under expenditure of political party. Okay.
Yes.
Because there is restriction of expenditure for political individual person. You know, right?
Yes.
Limits will be given by Election Commission of India. Next, allotted symbols to political parties. Okay. Registered political parties, there are two types of symbols: reserved symbols and free symbols. Okay. Reserved symbols and free symbols. Reserved symbols will be given to recognized parties. Okay. But free symbols will be given to unrecognized and this registered parties. See, for example, in Andhra Pradesh, just before election also, it is no guaranteed that Jansena will be giving the glass symbol, because they didn't get the required amount of votes. For getting a state party recognition, there is need for some seats, or else at least 8% of votes. In the last election, they got only 6% of votes. So, if at all they had got 8%, that glass symbol is specifically for them. In Andhra Pradesh, no other candidate can be given this glass symbol. But what happened here? Many other independent candidates, where this Jansen party is not contesting, they had been allotted glass symbol. Okay. So that is the difference. Free symbol can be allotted to any person. But once, see, for example, fan or this cycle symbol cannot be allotted to any other party in our state. Okay. So that's why it is called as reserved symbol. And all these will be guided under Election Symbols Reservation and Allotment Order 1968. And Election Commission of India is having complete responsibility and discretion in allotting the symbols. Okay. And ECA publishes its list specifying parties and their symbols through their notification. Okay. Next. Yeah, as I told you earlier, tomorrow tell me about national party and state party criteria. Okay. Next. Vote from home facility. Vote from home facility. What is this? Manmohan Singh used, and many people had used this. What is that? Senior citizens who are above 85 years of age, and PWD people, physically handicapped people who are having disability greater than 40%, they are allowed to vote from home. Apart from them, there are others also, a possibility for others also, but these two have been added recently by the Election Commission of India. Okay. And for the benefit and easy registration of these type of voters, Election Commission has created an app called Saksham app. Okay. Through these, they can register and also access the facilities. Okay. And with the Saksham app, Election Commission can also provide a wheelchair facility, transportation facility in near the polling areas. Okay. And now, who all are eligible in this vote from home facility? People aged 85 and above, persons with disabilities not less than 40%, media persons covering the polling day activities. Next, workers from essential services such as metros, railways and healthcare. Next, service voters and CAPF personnel. Okay. And how it happens? The main thing here is Form 12D. Whoever want to vote from home, they have to fill this Form 12D, and they have to submit it to Assistant Returning Officer within 5 days of election notification. Okay. After that, they will be, those person who had registered, they will be informed through an SMS or some other medium to how it will be taking place. Okay. They will be giving some specified time. At that point of time, the registered person must stay in house, and they will be, they must vote there. If they are not available in that first instance, again second chance will be given. And even after second chance, if they are not provided, they are not there in the home at that point of time, they cannot vote by going to the polling station also. Okay? Next, model code of conduct. Is it legally sanctioned?
No, not legally sanctioned.
Yes. It is just an executive resolution sort of thing. No statutory backing for this model code of conduct. All the parties have just agreed that we will be following this model code of conduct. Okay? But Supreme Court and Election Commission of India time and again use this model code of conduct provisions to give their judgments and all. Okay? And its primary objective is to ensure that campaigning, polling and counting procedure happens in orderly, transparent and peaceful manner. Okay? Next, indelible ink, this ink. Yeah. So, with which material this has been made? This has been made with silver nitrate. Okay? When we are applying this, due to interaction with the light and sun and this silver nitrate, it will be very difficult to erase this. Okay? And who is manufacturing this? Mysore Paints and Varnish Limited. Okay? Mysore Paints and Varnish Limited is manufacturing this. And it has been sanctioned under Rule 49K of Conduct of Election Rules 1961. Okay? Left forefinger, everyone will be put the ink. Next, Law Commission of India. Law Commission of India, again this is highly in news actually. Even question asked in the state PSC exams also. This is a non-statutory body. Recently, the time period of 22nd Law Commission of India have been increased. Generally, the time period of Law Commission is 3 years. Recently, the time period of the 22nd Law Commission have been increased. Okay? And this will be notified by Government of India, Ministry of Law and Justice. Okay? So, this Law Commission of India will be functioning under Ministry of Law and Justice. What is the main utility of this Law Commission of India? Advise government on specific policies or laws which have been given to them. Means there will be some sort of terms and conditions, terms of reference will be given to them. Based on those terms of reference, they have to give advices. Now, see for example, 22nd Law Commission have been given terms of reference with respect to how to implement the simultaneous elections, how to implement this Uniform Civil Code. Okay. Next, who is the chairman of 22nd Law Commission? Justice Rituraj Avasthi. Okay. Since UPSC is also turning some sort of factual, it might be useful in one of the statement. That's why I am telling about this. Now, the first Law Commission have been appointed in by Charter Act of 1833, chaired by Lord Macaulay. Right? Lord Macaulay is the first Law Commission chairman. It had come to India through Charter Act of 1833. Post independence, the first Law Commission established in 1955, and the chairman was C. Satyalwad. Okay? Now the present Law Commission is 22nd. Okay? 3-year term and with certain terms of reference. And the present 22nd Law Commission is having given these terms of reference. Okay? This simultaneous elections, UCC and any other things. Normally the General Law Commission checks whether any obsolete laws are there, any outdated laws are there. They will be checking and advising the government. Okay? Next. Yeah. We will be discussing the remaining in next class. Okay? I hope it is good.
Yes.
You're fine. Okay? Thank you.
Like a rapid revision.
Yes, sort of thing. And the major thing, since you all also know, in this 1 hour classes, we can't cover all the things. We will be covering the major things, which I am telling those as 5-star topics. These 3-star topics and 1-star topics will be giving those topics or some content regarding that. Okay? just to, these are some sort of confidence building sessions, that's all. Okay, for your rapid revision. Right. Okay, thank you.